We know that the law has evolved over the years in a way to permit the assertion of claims. For example, loss of consortium. Spouses have been able for decades now to bring claims when the injured spouse has suffered physical injury and emotional injury, and the spouse can assert a separate claim for loss of consortium. In 1980, it got liberalized even further to allow children to assert claims for the loss of consortium of injured parents. And then, by statute, about 8 years later, the flip side was permitted, and that is parents can assert claims for the loss of consortium of their children. But what about the nature of this claim? It is important to know that it is deemed a separate claim, although it arises out of the same injury. It is not only a separate claim, it is an independent claim. And that has very important implications when a case is tried or when it is negotiated. If there is comparative negligence on the injured party, that comparative negligence cannot be imputed to the people who assert the consortium claims. So the child of an injured worker would not have that injured worker's comparative negligence, if any, imputed to them. Their award would not be deducted by the amount of their father's comparative negligence or their mother's comparative negligence. Similarly, between spouses, the injured spouse's comparative negligence will not be imputed to the spouse who asserts a claim for loss of consortium. And the whole concept behind that is that it is an independent claim and unfair to tag or to attribute to the non-physically injured claimants, the one who is asserting a claim for loss of consortium, the negligence of the spouse or the parent. Now, let's talk about the nature of consortium claims. It is, of course, including marital consortium, marital relations, but it is including much more than that. It includes comfort, support, society, and assistance, and all the different combinations that I said at the beginning of this blog. So the father's or mother's support to the child, or the child's support and satisfaction they give to the parent, or the wife or the husband's support they give, and how it has been impacted or adversely affected by the accident is something that we assert on your behalf. We assert it on behalf of the family. Now, the child has to have been born at the time the cause of action arose. That is, at the time the worker got hurt, and that's just the way the law has been. Also, there has to have been a marriage in effect at the time the cause of action arose. That is, at the time the injured worker got hurt. So things can affect the consortium once you have a valid consortium claim, and it is certainly worth trying to sit down with your clients and the relatives to see and to learn how the consortium has really been hurt, because it is a worthwhile and important element of the overall claim. Thank you.